Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
I apologize, Judge. My internet is really slow at the moment.
That's okay.
Okay. An investigator called the number listed in the city of Houston for McCall Gill, who stated that he had not worked for Premium Care in 3 or 4 years. The investigator found the defendant to be Craig McPherson. Officer conducted a search on Craig McPherson, was not able to locate EMS.
Is this the right office?
Sorry, yes, I think that, I apologize, Judge. Okay. Yeah, sorry. I don't know if you, here, I'll just leave it. Just the customer. And I think it might be out of order. Oh, okay. Hold on. Oh, yeah, that's the thing I did. Okay.
Is it crotch or something?
Sorry. No, Your Honor, just our notes are all backwards, so that's on me. I'm sorry. There it is. On May 23rd, 2023, the complainant made a report that his scooter was stolen, and it was worth approximately $600. The complainant provided the serial number. On August 5th, 2024, the officer received a hit from Leads Online, which noted that the defendant pawned the scooter. The officer went to that Easy Pawn location at 12303 Bel Air and met with the complainant, who stated that the defendant pawned the scooter for $100. The complainant was able to provide the officer with the defendant's driver's license, and surveillance video showed that the identity of the defendant matched the video.
Yeah, but you know that he took the scooter from the place, from wherever it was, how do we know that someone didn't give it to him? I get it that he's pawned. I mean, perhaps, possession of stolen property, but theft.
So the allegation is the complainant is not the owner of the scooter, it's a pawn shop. So the allegation here is that the defendant
was charged with theft, right? So he has to steal it.
By acquiring or accessory. Oh.
Right, you have to acquire.
Yes, Your Honor.
So here, all he's doing is he's pawning it.
Ramsey?
It's a specific intent crime, so we have to,
The intent to deprive the pawn shop. So I think.
Well, the pawn shop is not it's the person who owned the scooter, which would be Mr. Elatari. That is the actual complainant, because it's his scooter that gets stolen, but we just don't know who steals it. We know that he pawns it, right? We get these so much, and it just. The problem is that the legwork would be somehow, okay, we get it, go back to the complaining witness, and then somehow see if is there a ring video that sees him stealing it, then. So, right. It is what it is. Mr. Salinas, I'm going to find no probable cause in your case. Please, be careful. We're not asking for much. All we want our streets to be safe. You know what I mean? All right, please. All right, Ms. Jenkins, you were charged with assault to a family member. You're facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 15th, 2025, in Harris County, Texas, an officer was dispatched to a family dispute. The officer met with the defendant, who stated that the complainant is her common-law husband. The defendant stated that the defendant attacked her and physically pulled her out of a vehicle and slapped her twice. The officer then met with the complainant, who stated that the defendant attacked him and, by striking him multiple times in his face, bit him on his nipple and felt a sharp pain on the back of his neck. The officer observed the defendant to have a bite mark on his nipple and a scratch mark on the back of his neck. Officers then spoke with a witness who stated they observed the defendant attack the complainant and continue even after they intervened. Officers observed no injuries on the defendant.
Any priors against us?
No.
And do we know what he wants? Ms. Jenkins, I'm going to find that there's probable cause to go forward with your case. There is a protective order that has been issued in this case. I would get to know it. If you do something to violate this protective order, the state can and will probably file a violation protective order against you. It's one of the worst cases you can pick up. I don't know if this person wants to have contact with you. So until I know, I'm going to order you not to have any contact with this person and not to be in possession of weapons.
So he would still like contact from what I can read here.
Is that from
He
a
said he
rip?
wants, it's from a RIP.
When was it performed?
The RIP was performed today at 9:14 a.m.
Okay, what?
He basically said that he wants to drop the charges.
I'm ordering you not to have any threatening or harassing contact against this person. You need to understand that what is threatening or harassing, it doesn't matter what you think, it's what he perceives. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
No.
Okay, I'll have you fill out an application. Deputy Miranda's going to give you an application. I'll take a look at it to see whether you qualify. I'll have you sign a reset with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. Do not leave until you sign it. Okay?
Okay.
Please. I'm looking at the order for protection now. Who is the complaining witness? What's the relation? It's boyfriend, right?
Yeah, 3 kids together.
Stop. No.
I'm looking now. We do not.
It's the guy, right?
It's the guy, and I don't have anything when I click on his name. And then when we tried to make contact with him, he got quite irate and said he didn't want to comply.
Well, the reason I'm asking is because in these order for protections, there is a residential restriction that prohibits you from going back to residence of where this person lives or where this person works. So that's why I was deciding whether to keep this on or take it off. The problem is that I don't want you guys to get in another situation where you're going to end up back in custody with a new case because you guys keep butting heads. So you need to be very careful. If you got a bunch of kids with this person and you guys are constantly butting heads, you're the one that's going to end up in jail with a new case if you guys start going at it again. You understand?
Yes.
So you need to be very, very careful, especially if you have a temper. If you, look, 99% of the people that are in jail now are there because they have no self-control. They wig out and they do whatever they want to do without thinking, if I do this, what's going to happen? If I say this, what's going to happen? And sometimes you have but a second to reflect. Use self-control, especially if you have kids. Because if your kids see this violence, what do you think they're going to do? The apple doesn't fall far from the tree. If you are like this and the kids see this, they'll be like, just like you. I'm going to take the residential restriction off. The only thing I'm counseling you is be careful, especially if you guys butt heads a lot. All right?
Okay.
You've got a great lawyer here. He will take care of you. Just listen to him if there's ever any issues. All right?
Okay.
Okay. Thanks, Ron. So they're going to file no contact, no weapons. I think that, let me see if we already have it. We do. So we'll have you sign the conditions now, and then after that, you're free to go. Okay? Thank you, Ron. Mr. Torres, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 15th, 2025 at 3:34 a.m., officers made a traffic stop and asked for a second officer to make scene as well. The officer observed a silver Chevrolet Malibu with no headlights on. The officer approached the driver's side and observed the defendant to be behind the wheel.
Hold on a second. Ladies, move away from each other, please. Miss Uloa.
The officer approached the driver's side and observed the defendant to be behind the wheel and operating the vehicle. The officer observed glassy eyes and odor of an alcoholic beverage. The second officer, a DRE, observed a mild odor of an alcoholic beverage, bloodshot eyes, and unsteady balance. The defendant stated that he was coming from the library and drank 2 beers. 18
The library?
from a library. I don't know, Your Honor.
Sure. Popular
and then-
library, I tell you.
He drank 2 beers 18 to 24 hours ago. SMSTs were conducted. It was a 6 out of 6 on the HDN, a 4 out of 8 on the walk and turn, and a 3 out of 4 on the one leg stand. The defendant was arrested and declined to provide a sample, so a blood warrant was signed.
I forgot what the stop was. What was the stop for?
No headlights at night.
Mr. Torres, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Yes, sir. Can you run him to see if he has any prior DWIs and if he has a driver's license?
Any priority WIs, his license is ineligible.
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 You are not allowed to drive. I don't care what's going on in your life, and I don't care what you got to do. I don't care if there's a burning building and you have to save 50 kittens. If you do not have a Texas driver license and liability insurance, you are not allowed to drive. Do you understand? Sir. You will be signing an affidavit with me today. This is a promise that you're going to make to me that you're not to drive. There's no justification that you can give for getting into a car and driving. Do you understand?
Yes, sir.
Hire a lawyer.
Yes, sir.
Okay, we are going to give you time. I'm going to have you come up here, swear to us that you're not going to drive. I will get you to Victoria. We will have you sign a reset. After that, you will get with Felicia for your bond conditions. And after that, you're free to go. Be careful and protect my community, because if I find that you're a danger to it, it's not going to go well for you. You understand?
Sir.
Okay, come on. Q, are you ready? Let's do it.
Absolutely. At least he knows that it's not.
It's gonna be on page 22 and 23.
Did we not do a TRAS on Miss Morgan? This is Morgan, right? I thought we did a TRAS.
We did.
This is we're not going to continue. This is your third trespass within a year. The next time, if you pick up another case, get ready. If you need any resources, we have resources here for you. If you need a place to sleep, if you need food to eat, you need somewhere to go, money, whatever, all you have to do is come back here and we will give you whatever you need. But living on the street takes its toll, and we're not going to continue to do this. Do you understand?
Yes, sir.
Next time, we will really get to the bottom of it. Do you understand, Ms. Moore?
Yes, sir.
You're charged now again with criminal trespass and interference with duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine on each of those cases. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record. It will stay there forever. This is it. I'm not going to continue to play this revolving door. Do you understand? How do you plead to both of these offenses? Guilty or not guilty? When I find you guilty, and I'll sentence you to 30 days in jail, and I'll give you credit for the 17. The next time you pick up a criminal case, come back. You've never once come back. Come back if you pick up another one. Do you understand? Good luck, Ms. Moore.
Thank you.
Hold up. Did they just say she was twerking at a red light before a DWI arrest? You can't make this stuff up. But legally speaking, that's where things get serious. The officer's observations of behavior, even before driving, can absolutely be used to establish probable cause for intoxication. So, funny moment aside, it's a key legal detail. Would you say that's fair policing or overreach?
Good morning, Mr. Saldana.
Pulling your own.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 15th, 2025, at 4:05 a.m., an officer observed the defendant operating a vehicle with an obstructed windshield. The defendant's vehicle was observed to have front-end damage that included a hood that was damaged and open with the bumper in the engine compartment. A traffic stop was initiated. The defendant had slurred speech, glassy red eyes, and a strong odor of alcohol on his breath. SFSTs were conducted. 6 out of 6 clues observed on the HGN, 2 out of 4 clues observed on the one-leg stand, 4 out of 8 clues observed on the walk and turn. The defendant consented to a breath test. The results were 0.144 and 0.129.
Douglas Bouillon?
What's the stop for? Because he's got a beat up car. Right?
Yes, so it states that he had an obstructed windshield due to the damage that to his vehicle.
Conclusory statement though.
Yes,
How?
Judge, because of the front end damage, the driver of the vehicle would not be able to see out of the front windshield, and it was considered a safety hazard.
Does it say how? I mean,
Excuse me, Adam?
how? Like,
What the damage was or
what's
how
the, how is the obstruction?
The states that the hood was damaged, the front hood was damaged and open.
To where it's facing, to where it blocks his, I guess, field of vision?
It states that the windshield was obstructed, so. It's right.
I guess I'll find probable cause for now, and then we'll talk to the defense lawyer. And if they can show me something differently, I guess I'll revisit it. Mr. Saldana, I'm gonna find probable cause for now. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm gonna test you. If I find that you're consuming alcohol or drugs, it's not gonna go well for you. Do you understand?
Yes, Your Honor.
Any prior DWIs, and does he have a license?
He does have an eligible driver's license, Your Honor, and no prior DWIs.
Okay. You are also not allowed to drive unless you have car insurance in your name. You must maintain liability insurance. That is also a bond condition. Do you understand?
Yes, Your Honor.
Okay, I'll have you sign a receipt with Victoria. We'll have you get your bond conditions with Felicia, and then after that, you'll be free to go. All right?
Thank you, Your Honor.
Please. Oh, do you have the ability to hire a lawyer?
Yes, Your Honor. I have a lawyer with the Texas Defense Criminal Group, I believe is their name.
You have a lawyer?
No, who's that? Oh, Gibbons. Saldana. Oh, yes, Gibbons is attached. He didn't print out on the docket though.
Oh,
So we can.
okay, so let's do this. Let's wait for your lawyer. Is your lawyer going to come here? Do you know?
They haven't, I texted them this morning and they haven't responded.
Okay, so let's do this. I'll have you sign and get all the paperwork ready. I'll have you wait a little bit to see if they show up, and then because we need to get a good date. So I'll have you sit, just wait a bit to see if they come. If they don't, then we'll reach out to them. Okay?
Thank you, Your Honor.
Please, for sure. Good morning, Mr. Bodian. So you're charged with failure to stop and give information after striking a highway fixture. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 14th, 2025, at approximately 11 a.m., officers were dispatched to the 10,400 block of North Tree Hollow Circle in LaPorte, Texas, in Harris County, in reference to a minor accident where a vehicle struck a light pole. The officer was advised by dispatch that a witness observed the suspect leaving the scene and were provided a description of the vehicle. The officer began to check the area and observed that a vehicle that matched the description with wiring hanging out of the front of the vehicle and front end damage. A traffic stop was initiated. The officer made contact with the defendant, the driver, and observed several car parts hanging several car parts, including a front bumper in plain view. The defendant stated that he struck the light pole and left the scene because nobody else was involved. Centerpoint, the light pole company, stated that the cost to repair would be approximately $3,000.
Mr. Bodion, I'm going to go find that there is sufficient probable cause to go forward with your case. Can you run his license to see if he has a valid license, please?
Yes, Your Honor.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance. Do you understand? Good. These are your bond conditions. If I find that you violate these conditions, if you pick up a new case, I will revoke your bond and put you in jail. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer, sir?
Yes.
Okay, we'll give you time to hire a lawyer. So what I'm going to have you do is I'm going to have you go to Victoria, sign a reset. We'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be on your way. All right? Do not pick up any new cases. All right?
Good morning, Inspector.
Good morning.
And you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 14th, 2025, at approximately 12:32 a.m., an officer observed the defendant outside of her vehicle twerking at a red light intersection. The defendant,
Twerking?
yes, sir. The defendant then returned to her car and drove southbound down Montrose Boulevard. The officer observed the vehicle failed to signal a lane change multiple times. A traffic stop was initiated. Officer observed the defendant to have the mild odor of alcohol upon her breath, slurred speech, and glassy eyes. The officer asked the defendant to exit the vehicle, and the defendant stated she had 2 glasses of gin with champagne at a bar. SFSTs were conducted. 6 out of 6 clues were observed on the HGN, 3 out of 8 clues observed on the walk and turn, 2 out of 4 on the one-leg stand. The DIC was read and the defendant consented to a breath test at 1:18 a.m. Then at 2:20 a.m., she stated she did not consent. A blood search warrant was signed and executed at 3:06 a.m.
All right. Any prior DWIs?
No prior, Judge.
License?
Eligible.
Ms. Bookman, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, you will go to jail. No more PR bonds. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer, ma'am?
Yes.
Okay, we will give you time. So what I will have you do is I'll have you go to Victoria, sign a reset. You'll get with Fleischer your bond conditions, and after that, you'll be free to go.
Thank
When you
you.
come back, please have a lawyer.
Wow, this part hits hard. The judge's warning about self-control isn't just courtroom talk. It's a real-world truth bomb. Judges often turn moments like this into moral lessons, especially in domestic cases where emotions run high. But here's the question. Does the lecture help, or does it just sound like scolding?
Please. Good morning, Mr. Garcia. Your lawyer came by here yesterday. We did probable cause. I'm going to now find probable cause. I mean, let's do it just for,
Okay.
so he can hear it, but you have the right to remain silent. Anything you say can and will be used against you, sir.
On March 15th, 2025, an officer was working at a crash scene in Pasadena, Harris County, Texas. At approximately 1:15 a.m., the officer heard tires squeal and a vehicle collision a short distance away. The officer observed a vehicle had collided with a fully marked police vehicle with emergency lights activated. The officer observed the defendant, the driver, and sole occupant to appear confused and have glassy eyes. The defendant exited the vehicle and the officer observed red glassy eyes, slurred speech, uncoordinated and lethargic movement, and the odor of alcohol emitting from his person. The defendant admitted to drinking 2 beers. SFSTs were conducted. 6 out of 6 clues were observed on the HGN, 3 out of 8 clues on the walk and turn, 2 out of 4 on the one-leg stand. The DIC was read and the defendant consented to provide a breath specimen. The results were .134 and .123.
No prior DWIs, right?
No prior DWS.
Okay, Mr. Garcia, I'm going to find that there's sufficient probable cause to go forward with your case. I am ordering you not to consume alcohol. Do you speak English, right? Okay, I'm ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming, I will revoke your bond and put you in jail. No more PR bonds. Do you understand? Do not pick up any new cases. You've got a great lawyer. Listen to him and he'll take care of you. I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Mr. LeGrand and he'll tell you when you have to come. All right? So I'll have you go to Victoria Center Reset. You'll get with Fleischer for your bond conditions, and then you're free to go. All right. Good morning, Mr. Otto. Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 13th, 2025, at approximately 10:15 p.m., an officer initiated a traffic stop at the 5804th block of Southwest Freeway on a black Alfa Romeo. The officer observed the motor vehicle weaving in and out of traffic at high speeds, endangering other motorists on the road, almost striking multiple motor vehicles. The officer had to increase to speeds up to 100 miles per hour to catch up to the motor vehicle and traveled about 6.1 miles. The defendant admitted to driving over 100 miles per hour in an attempt to catch up with another motor vehicle. A NCIC TCIC check revealed the motor vehicle had no valid insurance. The defendant was identified by his Illinois driver's license.
So can you run him to see if he does have a license, please?
His Illinois driver's license is valid.
Mr. Otto, I am forwarding you as a condition of your bond not to drive maniacally again. If I find that you drive like this and put other lives in danger, I will revoke your bond and put you in jail. Do you understand?
Sir.
No reckless driving, racing, street takeovers, anything of this manner. If I find, first thing, I'm going to put you in jail. The next thing, I'm going to take your ability to drive away. Living in a city this big without the ability to drive blows. Do you understand?
Sir.
Do you mind filing this condition, please?
Yes, sir.
You're also not allowed to drive unless you have valid liability insurance in your name, car insurance. If you don't have car,
Bills are running.
okay. I don't care if you're driving the Dodge Patas. If you don't have car insurance, you're not to drive. Do you understand?
Sir.
Do you have the ability to hire a lawyer, sir?
Yes.
Did you want to apply for a court-appointed lawyer? Okay, we will give you time to hire a lawyer. I'm going to have you go to Victoria Center Reset. After that, I'll have you take a seat in the jury box. So we'll get your bond conditions. Do not leave until you sign our bond conditions, and then we'll let you go hire a lawyer. Please. What was your last name?
Patterson.
Morning, Mr. Patterson. Good morning. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to, have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 14th, 2025, in Harris County, Texas, an officer met with the complainant who stated that the defendant is his stepfather. The complainant stated the defendant was not happy with the yard work the complainant had done and punched him in the face several times. The officer observed the defendant to have a bloody nose, swollen lip, and bruising. The defendant admitted to punching the complainant in the face due to the complainant throwing a bottle of water at him. So the defendant stated that he punched the complainant in the face because the complainant threw a bottle of water at him. Complainant said he punched him in the face because he was unhappy with the yard work he did.
Do we know whether they want to have continued contact or no?
We have not been able to get into contact with the complainant yet, Judge.
So, Mr. Patterson, there is sufficient probable cause to go forward with your case. I'm ordering you not to have any contact with this person, not to be in possession of weapons. These are your bond conditions. If you violate these conditions, well, first of all, you have a protective order. If you violate the protective order, they can file additional cases against you. A violation of a protective order, it's one of the worst cases you can pick up. And in our assault, if you violate those conditions, I will revoke this bond. You understand?
Yes, sir.
So no contact, no weapons. Do you have the ability to hire a lawyer?
No, sir.
I'll have you fill out an application. I'll look to see whether you qualify. I need to know everything about you, how much money you have in the bank, what kind of, everything about you, and then I'll take a look to see if you qualify. Deputy Miranda, do you mind giving me an application, please? I'll have you sign a receipt. Victoria will have you take a seat. Do not leave until you sign our bond conditions.
Yes, sir.
Okay? All right. Good morning, Mr. Sanchez. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Judge Fleischer. On March 14th, 2025, in Harris County, Texas, officers were dispatched to a disturbance. Upon arrival, the officers observed the defendant attempting to force entry into the residence. The officer met with the complainant, who stated that the defendant is his boyfriend of 6 years. The complainant stated that the defendant arrived intoxicated and became angry after she told him that he was intoxicated. The defendant then forced his way into the bedroom, grabbed the complainant by the hair, and pinned her to the bed while he scratched her under the eye, causing pain. The officer observed a visible scratch.
Mr. Sanchez, I'm going to find that there's sufficient probable cause to go forward with your case. I am now ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any illegal drugs, I will put you in jail. No more PR bonds. Do you understand? I am also ordering you not to have any contact with the complaining witness in this case and not to be in possession of any weapons. There's a protective order that has been issued in this case. I would get to know it. If you violate this protective order, the state can and will file a violation protective order against you. It's one of the worst cases you can pick up. Do you understand?
Sir?
Okay, Mr. Sanchez, do you have the ability to hire a lawyer?
Yes.
Okay, we will give you time. I will have you sign a receipt with Victoria. We will have you take a seat in the jury box while I get your bond conditions. I'll have you sign it, and after that, you'll be free to go. Please.
Judge, these are for me.
No contact, no weapons, please. Oh, no, don't worry about it. You're right. Yeah, because he's being monitored. Yeah, sorry.
Okay, pause right there. This is what lawyers call a probable cause hearing. Basically, the judge decides whether there's enough evidence to move forward, not whether the person's guilty. Notice how the defense is pushing back on intent here, pawned property versus stolen property. What do you think? Should pawning something automatically make you guilty of theft?
So no alcohol, drugs, randoms,
No contact.
no contact, no weapons. Yeah,
Thank you.
thank you. Ladies, both of you are charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On February 25th, 2025, at approximately 12:57, officers arrived to a Target store at 2580 Shern Street in Harris County, Texas, for a theft in progress. The complainant stated that the defendants passed all points of sale without paying for the merchandise. The officer viewed security footage and saw that the footage of the defendant and the co-defendant passed all points of sale without paying for items that were selected and placed in either the shopping cart or inside the defendant's purse. The total amount stolen was $546.45.
Did they both?
Are they together? They both stole
Yes,
the
Your
whole
Honor,
thing?
they were both together and they both had.
Okay. Ladies, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering both of you not to go to any Target for any reason. Do you understand? If you violate these conditions, if I find that you pick up a new case, I will revoke your bond, put you in jail. No more PR bonds. Do you guys have the ability to hire a lawyer? Do you have the ability to hire a lawyer? Would you like to apply for a court-appointed lawyer? I'm going to have you both fill out applications. We'll see whether you qualify. And I need to know everything about you, okay? How old are you, man? How old are you, man? Okay. Deputy Miranda, do you mind giving the applications? We're going to have you, I'm going to have bond conditions created for you to sign. Do not leave until you sign our bond conditions. Otherwise, I will issue a warrant, okay? All right, please.